This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about the problems of a pro se litigant who is presumed to have knowledge of the law, and why, because he didn't, res judicata eliminated a second suit against his insurer because a final judgment prohibits the right of a litigant to a second try after settling. J.C. Robinson, Jr., pro se, appealed the trial court's summary judgment decision in favor of defendant Progressive Insurance Corporation in a case entitled J.C. Robinson, Jr. versus Progressive, a April 17, 2025 decision of the Court of Appeals of Ohio. In May of 2024, J.C. sued Progressive on behalf of himself and his minor daughter, E.R. J.C. claimed that the Robinsons were involved in a hit-and-skip rear-end motor vehicle accident in November 2023. Resulting in property damage, physical and mental injuries, medical expenses, lost income, and loss of enjoyment of life. J.C. claimed that the Robinsons presented to an emergency room after calling 911 following the motor vehicle accident and that their medical treatment was ongoing. Progressive filed a motion to dismiss the CP complaint in its entirety. Progressive argued that the CP complaint was barred by res judicata and claimed preclusion, noting that this was the second lawsuit the Robinsons filed against Progressive stemming from the motor vehicle accident. The Robinsons previously filed a complaint in a case entitled J.C. Robinson, Jr. versus Progressive in Cleveland Municipal Court called the MUN, M-U-N, or Municipal Complaint, which was dismissed with prejudice in March of 2024. Progressive filed a supplemental motion for summary judgment. However, J.C. argued that Progressive was responsible for 100% of the Robinsons' medical bills, pain and suffering, and loss of wages, and those claims had not been settled. In September of 2024, the trial court granted Progressive's motion for summary judgment for the reasons argued in the briefs, namely res judicata, and J.C. appealed. J.C. argued that the trial court erred in granting summary judgment because it was unreasonable, unjust, and unconstitutional to strictly apply the doctrine of res judicata when the Robinsons' claims were not ripe for review, litigated, or dismissed on the merits. Pro se litigants, like J.C., are presumed to have knowledge of the law and legal procedures and are held to the same standard as litigants who are represented by counsel. Indeed, pro se litigants are not entitled to greater rights, and they must accept the results of their own mistakes. One of the principal purposes of summary judgment is to isolate and dispose of factually unsupported claims or defenses. There can be no genuine issue as to the material facts, since a complete failure of proof concerning an essential element of a non-moving party's case necessarily renders all other facts immaterial. After the moving party's initial burden is satisfied, the non-moving party may not rest upon the mere allegations or denials in the pleadings. Rather, the non-moving party's reciprocal burden is triggered, requiring it to set forth specific facts showing that there remains genuine issues for trial. A trial court may consider evidence other than the materials specified in the motion if no objections are raised. Res judicata ensures the finality and stability of judicial decisions, deters vexatious litigation, and allows courts to resolve other disputes. The doctrine prevents a party from relitigating an issue or claim that has already been decided in a final appealable order or a valid final judgment in a prior proceeding, and could have been raised on appeal in that prior proceeding. The Ohio Supreme Court adopted res judicata's modern application, which includes claim preclusion and issue preclusion. The claims raised in the CP complaint are barred by claim preclusion. First, a court of competent jurisdiction rendered a valid final judgment on the merits in an earlier action. A dismissal with prejudice is a final decision on the merits. The current case involves the same parties or their privies. The CP complaint raises claims that were or could have been raised in the MUN or municipal court complaint. JC pleaded the same breach of contract, unfair claims practices, and bad faith claims which were previously raised in the MUN complaint. The CP complaint arises out of the same operative facts and evidence as the MUN complaint. The MVA and Progressive's handling of the Robinsons' claims under JC's automobile insurance policy, an exception to the res judicata doctrine, will not apply when the parties had a full and fair opportunity to be heard on the issue. After Progressive moved for summary judgment, JC's reciprocal burden was triggered. To survive summary judgment, JC was required to set forth specific facts rebutting the application of res judicata and showing that genuine issues remain. JC had not done so. The record reveals that JC had a full and fair opportunity to litigate the Robinsons' claims, accepted a settlement from Progressive, voluntarily requested the dismissal of the MUN complaint with prejudice, and failed to pursue a direct appeal of the municipal court's final appealable order. JC failed to provide any evidence to rebut Progressive's res judicata argument, and because the doctrine of res judicata applies and no exception is warranted, the trial court did not err and granted Progressive's motion for summary judgment, and the Court of Appeal affirmed that judgment. In my opinion, insurance companies must be treated like any other litigation. Once a suit is settled and judgment entered, its dispute with JC was resolved. Yet JC, acting as his own lawyer, sued again, seeking another bite out of Progressive. The Court of Appeals wisely affirmed the trial court's granting of the motion for summary judgment. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you can also subscribe to these videos on YouTube and on rumble.com. They're all free. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing for a very small fee to my Substack publication. And please tell your friends and colleagues about this blog so that they too can subscribe to the blog, the videos, and to my Substack publications. Thank you for your attention.